The accused who appeared at Nakawa Magistrates Court on charges of common nuisance and being idle and disorderly include Thomas Kanzira, Faizo Salima, Olupot Bernard Ewalu, Hamala Ediga, and Arajabu Musinguzi. The case presided over by Magistrate Rita Chidasa. Prosecution led by Dorine Klima first amended the charge sheet by dropping the charge of being idle and disorderly, remaining with one count. The accused thereafter asked court to be granted bail by each presenting two sureties. Prosecution asked court for more time to verify the presented documents by the sureties of the accused. Magistrate Rita Chidasa overruled the prosecution's prayer and granted the four accused persons bail of 200,000 each cash and sureties 500,000 not cash. Court, however, declined to grant Arajabu Musinguzi bail for failure to confirm to court his press overboard. Court resumed on 14th August 2024 for mention of the case. Meanwhile, Machine Magistrates Court has charged a businessman, Tonny Mutabingwa, on 2 counts of fraudulent procurement of a land title and forcible entry. Prosecution alleges that Tonny Mutabingwa, between December 2022 and January 2023, at the office of the Registrar of Titles KCCA in Kampala City, willfully and fraudulently procured a certificate of a land title comprised on Chadondo Block 2544, plot number 8328, at Kisugu in Kampala District.
Your glasses, I would like to look at you. You're Mutabingwa Tonny, you're aged 52 years. You're a businessman resident of Namwaya Central Zone, Machinje Savaga Municipality in Wakiso District. You're charged with 2 offenses. The first one is that you're charged with fraudulent procurement of a certificate of title contrary to sections 174 subsection 1 of the Registration of Titles Act, Cap 240. The particulars are that you, Mutabingwa Tonny, and other people between December 2022, Mutabingwa Tonny and others who are still at large between the 3rd and 4th of March 2023 at Kisugu Machinje Division in Kampala City in order to take possession of land comprised in Chadondo Block 244, Plot 8328 at Kisugu. You mobilized graders, a group of persons armed with machetes. You violently cut down crops, trees, graded, subdivided, and sold the land. Have you understood the charge?
Prosecution also alleges that Tonny Mutabingwa hired a group of machetes and forcefully with violence entered on the said land belonging to Joseph Galiwango, fenced it with iron sheets, on allegations that he acquired it from Ndagile Anet. Ndagile Anet got possession of the said land by fraudulently using a forged court order, which he allegedly acquired from Nakawa High Court. Prosecution led by Anet Victoria informed court that inquiries are still ongoing.
We have instructions to apply for bail. Our client aware, Your Worship, that the prosecution has clearly told this court that investigations are incomplete and still ongoing. And further, Your Worship, buttressed in the laws governing this court on bail applications, particularly the Constitution, in brackets, bail guidelines for courts of judicature, directions 2022, Your Worship, and pursuant to Section 77, Your Worship, of the laws governing this court, that is the Magistrates Court Act. Your Honor, the supreme law of the land, which is the Constitution of the Republic of Uganda. Your Honor, accordingly, the guaranteed right to liberty under Article 23 for all innocent persons in Uganda, including their children, Your Honor, are inalienable in the circumstances of sub-rule 2 or rule 2 and Article 23 of the Constitution of the Republic of Uganda. Your Honor, we have strict instructions as officers of court to advise that expeditious disposal of cases and bail applications is usually under Rule 8 to the bail guidelines, Your Honor, are advisable for as long as we comply with the Rule 12, which enumerates properly the contents of an application of this nature. Your Honor, we have moved forward, and my colleague will address this court on the sureties available. But presented before this honorable court, as my colleague will do so, there is a copy of the applicant's national identity card. It has been introduced to this honorable court by the chairperson of the local council area of his residence. Your Honor, the implications of this introduction, other than the rules, are that under the Local Council Courts Act 2006, there is a collegiality between courts of law. They have confirmed, and as my colleague will definitely expound, we continue. They have confirmed that he is within their discipline. The chairperson
Introduce him
yes.
in the capacity while exercising judicial authority or in his capacity as a person in charge of the residence. Therefore, we want to notify us that the accused is resident
Within the jurisdiction. Yes, Your Worship.
I proceed to present the sureties what for this honorable court allow me at that the accused person is a citizen of this country, as clearly evidenced by the production of the national ID, both in original and in copy. Your Worship, the accused person is a businessman by occupation, and he deals in real estates. It's upon that part of your honor that I proceed to present to you the sureties before this honorable court. Your Honor, the accused person has three sureties in this court. The first one, Your Honor, is called Kiza Hakim.
Kiza Hakim.
That the accused person will be admitted on bail. Because the offense under which the accused person is charged with is bailable for this honorable court. Our argument is still our humble view that he has satisfied the condition of having a fixed place of abode. Your Honor, the accused person has presented three sureties before this honorable court. And they are all business people responsible. And we pray that we find them to be substantial based on the particulars which we have available in this honorable court. Your Honor, we have taken the initiative of inquiring from the sureties whether they know their obligations as sureties, and each of them clearly understands why they are here, what they have come to do, what they are supposed to do. If this court goes ahead and entrusts them with their chosen person to be reporting while on bail, Your Honor.
Tonny Mutabingwa denied all the charges against him. Magistrate Elisha Inait will release the accused on a cash bail of 1 million and sureties 20 million non-cash.
In applications of this nature, I must state that the basis for bail under Article 23 is rooted in Article 28, which establishes presumption of innocence. I will simply put it that innocent persons are enjoined to enjoy their liberty. They are not meant to be in prison. They shouldn't be constrained in any form unless for serious reasons as to health and other causes when such rights can be suspended, like COVID-19. This, however, does not mean that the Constitution declares them completely innocent, but rather raises a presumption which can be negated by providing evidence to rebut the same. The reality is that the applicant herein is an accused and must be dealt with as such. This, therefore, moves court to request for recognizance from an accused person to secure their presence at the next hearing. Inasmuch as I agree with counsel for the accused and also supported by prosecution that I hold discretion, I must exercise it in conformity with the law and also bearing in mind society needs, because judicial power is derived from the people and ought to be exercised in accordance with the values, norms, and aspirations of the people. These values, norms, and aspirations are what are outlined in the Constitution, including Article 23 and Article 28. And give to the people a complete package of justice. The applicant has presented 3 sureties, aged 40, 31, and 31. The first surety is a friend. The second and third sureties are friends and nephews to the applicant. Prosecution argued against the second and third sureties, meaning that she took no issues with the first surety, inasmuch as he is also younger than the applicant. State Council invited me to reject these sureties because they are all younger than the applicant and are even nephews to the applicant and couldn't compel him to come to court. Applicant's counsel in rejoinder argued that the age of the surety is immaterial because no law prohibited them from standing as sureties. Instead, they implored me to use it as an opportunity since the sureties are rather younger and can remind the accused to come whenever is required. I have carefully listened to both. My analysis is already laid in the preamble to this ruling. The sureties act as a safeguard for accused disappearance. I agree with the defense team that no law disqualifies the sureties herein to stand surety for an applicant. They are adults with known residences and businesses. The question of age is rather a controversial question. If courts were to purely admit sureties based on the quantum of years, then we would find the courts finding 90-year-olds and 100-year-olds as substantial. But are they really substantial? I opine that the question of age should be looked at along with the considerations like what influence does the surety have on the applicant. For example, a child and a parent. Would the courts be justified in rejecting a child to stand for his or her parent merely because the parent is much older than the child? I believe that the child would be the most suitable surety that can remind a parent to appear whenever required. These sureties are nephews of the applicant. I have established from them that they understand their responsibilities and consequences of non-compliance with their responsibilities. I accordingly find them substantial. That being the position, I allow this application. However, to safeguard myself further, I shall grant an accused a cash bond of 1 million shillings. Each of the sureties shall bind themselves in the sums of 20 million shillings, not cash. We will get a date for mention.
Court resumed on 30th September 2024. For mention of the case.
No.